Please be seated. Next question would be for MP Boda.
Thank you, Mr. Speaker, sir. B1096, sir.
Mr. Speaker, sir, I'm informed by the Mauritius Shipping Corporation Limited that on 12 April 2021, MV Mauritius Tokecha left Mauritius for its dry docking in Sri Lanka. The vessel reached Colombo on 20th April and with 28 crew members on board, comprising of 4 foreigners and 24 Mauritians. The 4 foreign crew members were the master, the chief officer, the second engineer officer, and the third engineer officer. The vessel came back to Mauritius on 14 September 2021 after the dry docking. Mr. Speaker, sir, when the vessel reached Sri Lanka, COVID-19 pandemic was its full swing worldwide. On 22nd of April 2021, a first meeting was held with the shipyard on board the vessel. The repairs work started at berth from 23rd of April 2021 up to 5th of May. In fact, Mr. Speaker, sir, procurement of parts, repairs of crane and testing were completed on 26th of August 2021. The vessel left Sri Lanka on 27th August 2021 and reached Mauritius on 3rd of September. All crew members who were in Colombo for the dry docking returned to Mauritius. With regard to Part A of the question, I'm informed by the MSCL that in practice, during a dry docking exercise, whether in Mauritius or abroad, the crew members are paid their salaries as per the contract of employment signed with the MSCL. To that end, no disturbance allowance has been paid to the crew members as they have worked as per the normal scheme of duties as per the contract of employment, and there is already a provision of monthly allowance of 3,000 rupees for crew working on board vessels in their salary. As regards Part B of the question, it has never been and will never be the policy of MSCL to replace the local workers by foreign workforce. As per prevailing policy at MSCL, as far as possible, local workers are recruited on board the vessel. However, at times MSCL has to resort to the employment of foreign crew to cater for the shortage of seafarers on the local market for certain positions. This has been the case for MV Tokecha during its dry docking, where 9 crew members signed off after they were infected with COVID-19. Thus, MSCL had to resort to foreign workers, Sri Lankan foreign workers. In fact, I'm informed by the MSCL that out of those 9 crew members who signed off, 6 have already been re-employed on board the Mauritius Tokecha. Mr. Speaker, sir, the required posts on board the vessel, which are scarce and not easily available in Mauritius, include the master, the second officer, the third officer, chief engineer, second engineer, and sometimes of able seaman deck and able seaman engine also. I'm further informed by the MSCL that as at date, out of 34 crew members, there are 8 foreign crew members on board MV Tokecha. The 8 foreign crew members on the vessel occupy the post of like second officer, third officer, second engineer, third engineer, able seaman deck, and most are Sri Lankan, Indian, Malagasy, and Malagasy. I'm informed also that training for seafarers on deck and in engine room are being provided by the Mauritius Maritime Training Academy in collaboration with the shipping division of my ministry to replace these foreigners as far as possible, of course.
I thank the Honourable Minister for the answer. May I ask the Honourable Minister whether he is aware in what harsh conditions the Mauritian crew lived during those months in Sri Lanka?
Mr. Speaker, sir, we all know that the world, and especially Honorable Boda, we were together, we know how harsh it was for not only for our crew over there, but worldwide in Mauritius, but everywhere, even for our Mauritian working on cruise vessels abroad. So many were stranded. So it was a no normal situation. But one thing, Mr. Speaker, sir, as far as when they were found COVID positive, the Mauritius Shipping Corporation took care with all facilities we got to medical care given to them in Sri Lanka over there.
Given the fact that the crew was away from home for 5 months in harsh conditions, may I ask the Honourable Minister whether a special allowance cannot be granted to them? I think they have made a request to him, and I think that on humanitarian grounds, beginning what he says, that the disturbance allowance is not payable because of the contract, and the dry docking allowance either, can he consider the possibility of a special allowance being given to them, given the harsh conditions that they spent, in the harsh conditions in which they spent 5 months in Sri Lanka?
Mr. Speaker, sir, COVID-19 pandemic caused major disturbance in all sectors. Many of, we can recall, as I said rightly, not only in the shipping, but in the police, everywhere. Now we start with COVID disturbance allowance program. I know where to start and where to end with this. But anyway, this will be sent to the Mauritius Shipping Corporation Board for them to take stock of it and decide upon that.
Thank the Minister for his stand, Mr. Speaker. May I ask the last question?
Exceptional.
May I know from the Honourable Minister what is the status today of the 24 members of crew, whether they're still on board the ship, whether they have been granted the possibility of upgrading their skills at the school? What is the status of that crew today, as he has already confirmed that foreigners are not going to be recruited unless there's no other possibility?
Mr. Speaker, sir, as I mentioned, actually we have 8 foreigners working on board, and out of the 9 who signed off, 6 has been re-employed on board. So it's an ongoing program on board with regard to training and to upgrade our crew on board Mauritius Tokecha. There are courses which are being done by the Mauritius Maritime Training Academy, and this is done at the cost of the Mauritius Shipping Corporation.
Next question.
B1097. Mr. Speaker, sir, I am informed that there are presently 174 pig breeders who have been allocated state land for pig breeding activities at Saint-Martin at 2 different phases known as Saint-Martin 1 and Saint-Martin 2, which are adjacent to each other. There are 39 pig breeders in Saint-Martin 1 on agricultural state land of an extent of 10 arpents. They fall under the purview of the Cooperatives Division of the Ministry of Industrial Development, SME and Cooperatives. These pig breeders had backyard pig rearing activities in regions such as Plaisance, Tenley, Camp-le-Vieux and Rosil, and had relocated to Saint-Martin 1 in 1983. They are regrouped under the Plaisance Pig Credit and Marketing Cooperative Society. As for Saint-Martin 2, there are 135 pig breeders on agricultural state land of an extent of 25 arpents. Mr. Speaker, sir, following the outbreak of African swine fever in 2007, a policy decision was taken to establish Saint-Martin 2 in order to relocate pig breeders operating in their backyards in the regions of Albion, Rochebois, and other areas in the vicinity of Port-Louis. 71 out of these 135 pig breeders have a valid lease agreement of a period of 7 years. The remaining 65 breeders' lease agreements have expired and will be renewed after a survey exercise by my ministry and after obtaining a parcel identification number from the Ministry of Housing and Lands. The plots of land leased to these breeders vary from 10 to 30 perches. Officers of the Land Use Division of my ministry and the FARE carry out site visits at Phase 2 of, that is Saint-Martin 2, at least 4 times a year to ascertain whether the lessees are occupying the plots of land and complying with other conditions of the lease agreement. Mr. Speaker, sir, in relation to Part B of the question on pollution, I wish to inform the House that several government agencies, including my ministry, the Ministry of Health and Wellness, the District Council of Black River, and the Police de l'Environnement have received complaints with regard to odor and wastewater nuisance originating from Saint-Martin Phase 1. Furthermore, FARE has also received complaints with respect to the following issues, namely odor nuisance emanating from Saint-Martin, air pollution due to burning of domestic waste, discharge of waste in Magenta Canal, overflow of waste on access roads, and erratic water supply. The CWA carried out a site visit in Saint-Martin 1 in November 2020, and following an assessment, it was noted that the central wastewater facility thereat was not functioning properly. In the light of this assessment, remedial action was taken by my ministry, and a contract for the cleaning and rehabilitation of the wastewater system at Saint-Martin 1 was awarded to contractor Prakash Fulchan Contracting Limited for an amount of 3.5 million rupees. The project was completed in October 2022, and since then, all waste emanating from Saint-Martin 1 is channeled through this central waste treatment facility, which is fully operational. Furthermore, FARE is giving constant training to pig breeders on good husbandry practices at both Saint-Martin 1 and 2. Mr. Speaker, sir, contrary to Saint-Martin 1, Saint-Martin 2 is not provided with a wastewater treatment facility due to technical reasons. Therefore, at Saint-Martin 2, most of the breeders are using an uncovered absorption pit to collect the waste. The remaining breeders have installed septic tanks. Around 20 of the breeders do not have a waste disposal system. With a view to alleviating the problem of obstruction of drains caused by discharge of waste at Saint-Martin, my ministry is proposing the construction of individual waste treatment plants for each breeder and maintenance of the new individual treatment plants at regular interval of 3 months. In that respect, a study will be carried out on the feasibility and cost estimate for this project with technical specifications, following which funding will be identified in consultation with the Ministry of Finance. Mr. Speaker, sir, as for Part B of the question concerning water shortage, I have been informed that such situation was prevailing during the dry season, which had in fact affected the whole island. However, during the said dry season, the CWA was assisting the breeders through provision of water tank service. Furthermore, Saint-Martin Phase 1 also obtains water from a borehole. Necessary action is being taken by the CWA to connect the breeders in Saint-Martin 1 with domestic water supply. All the farms in Saint-Martin Phase 2 are already connected to the domestic water supply. My ministry is in the presence of a proposal from the Plaisance Pig Credit and Marketing Cooperative Society to review the penalty ceiling limit of borehole water to 3,000 cubic meters and to fix the daily water extraction per day by the said cooperative society to avoid payment of penalty. The said proposals are being looked into. Mr. Speaker, sir, coming to Part C of the question in respect of an integrated plan at Saint-Martin, my ministry is proposing the setting up of a technical committee to look into the said integrated plan. With regard to infrastructure on site, I am informed that the main road and internal access roads are asphalted and that street lighting is available. Some of the breeders have secured their respective plots with metallic fencing as well as CCTV cameras. Thank you, Mr. Speaker.
I would like to thank the Minister for his reply, which is very comprehensive, because this is a region, the big breeders, which are the small breeders, which have been facing a lot of problems over the years, and different governments have been trying to help them. Can I ask the Minister, I'm I would say to through you sending a request by the pig breeders, if you can see and attend to these requests, and whether it is agreeable to go and to have a site visit with the cooperators, the responsible authorities as well, and the Minister of Cooperative, to see the visu by himself, the situation actually prevailing at the Saint-Martin site 2, I say.
Mr. Speaker, so we shall look into the matter jointly with my colleague, the Minister for Cooperatives, Industrial Development and SMEs. Thank you, Mr. Speaker.
Supplementary question. Can I make a request to the Minister, being given that there are underground water tables in the region, and also the villages of Canot and Gokayu, which are affected, and also Albion, with regard to these pollution problems, can I make a request to the Minister at least to see with the Minister of Environment what can be done at least to alleviate the problem of pollution pending the implementation of the projects mentioned by the Minister?
Mr. Speaker, so we shall indeed have a holistic approach to these long-standing problems around Saint-Martin. As I have stated in my reply, a number of initiatives are being implemented, and the requests of the cooperative society, the requests will be taken into consideration. Thank you, Mr. Speaker.
MP Kirin.
B1098.
Monsieur le Président, je remercie l'honorablement pour cette question. J'ai été informé par la Gambling Regulatory Authority que la Horse Racing Division est entrée en fonction en janvier 2022, avec pour principal objectif de réglementer, contrôler et surveiller les courses hippiques à Maurice conformément à la section 15A1 de la Gambling Regulatory Authority Act. En ce qui concerne la partie A de la question, j'ai été informé que le coût encouru par le gouvernement par l'intermédiaire de la Horse Racing Division pour la saison des courses hippiques 2022 était de 51,7 millions de roupies. Le détail des postes se présente comme suit. 29,3 millions de roupies au titre des frais de laboratoire pour les tests d'échantillons avant et après les courses et hors compétition. 15,3 millions de roupies pour les honoraires des expatriés employés comme Head of Horse Racing, Stipendiary Stewards and Handicapper. 5,2 millions de roupies pour l'équipement informatique, le mobilier, le matériel de bureau et d'autres dépenses annexes. Et 1,9 million de roupies pour les frais de personnel. S'agissant de la partie B1, concernant la collecte de taxes, les montants sont comme suit. Pour l'année 2020, 476 200 000 roupies. 2021, 413,2 millions de roupies. 2022, 446,4 millions de roupies. Pour les autres revenus, à savoir les licences, les pénalités et autres, 2020, 58,6 millions de roupies, 2021, 57,3 millions de roupies, 2022, 53,4 millions de roupies. S'agissant de la partie C de la question, concernant les montants alloués par le gouvernement, pour l'année, je vais parler en année fiscale parce que c'est pas en termes d'année calendaire. Donc pour l'année financière 2020-2021, 43 millions de roupies, 2021-2022, 37,9 millions de roupies, 2022-2023, 92 millions de roupies. Merci, Monsieur le Président.
Monsieur le Président, les spécialistes de ce secteur avancent que les revenus sont à la baisse et les chiffres que vient de mentionner l'honorable ministre vont définitivement dans ce sens. De ce fait, l'honorable ministre peut-il nous dire quelles sont les mesures prises par son ministère pour lutter contre les paris illégaux qui constituent le principal fléau de ce secteur?
Monsieur le Président, je laisse le soin aux régulateurs, de par leur indépendance, de proposer des mesures pour mieux contrôler les causes. De notre côté, nous apportons tout notre soutien aux régulateurs pour mieux réguler ce secteur. Donc, n'étant pas moi-même un spécialiste des causes, je l'ai dit plusieurs fois ici, je ne pourrais, de prime abord, comme ça, sorti de nulle part, avancer des propositions pour dire comment mieux réguler les causes, parce que je ne suis pas un expert des causes. Merci.
Monsieur le Président, avec ce qui se passe actuellement au Champ de Mars, le public a perdu confiance dans cette industrie, et principalement avec la nouvelle compagnie organisatrice de causes. De ce fait, le ministre peut-il nous dire ce que son ministère compte faire pour restaurer cette confiance?
Monsieur le Président, je pense que, n'étant même pas un expert concernant les chevaux, je sais qu'il y a eu des problèmes avec Covid, on n'a pas pu organiser les courses avec le confinement, avec le fait qu'il fallait avoir une distanciation. Il y avait eu beaucoup de problèmes concernant l'organisation des courses. Par la suite, nous avons un nouveau organisateur qui est en train d'organiser les courses. Nous allons voir comment ça évolue et par la suite, nous ferons les recommandations au niveau de mon ministère avec la GRA.
MP Amos.
B1099.
Yes, Mr. Speaker, sir, I would refer the honourable member to my reply given to PQB 848, and I reiterate that the Livestock and Veterinary Division of my ministry has issued, from January 2022 up to date, 41 movement permits to the Mauritius Meat Authority, following which 842 cattle, 1,723 sheep, and 1,562 goats have been moved from Rodrigue to Mauritius. I wish to point out that it was in January 2022 that the restriction on the movement of animals from Rodrigue to Mauritius was partially lifted. Thank you, Mr. Speaker.
May I know from the Minister when was the last importation of cattle from Rodrigues and when will be the next one?
It all depends on the movement of the ship from Mauritius to Port Maturin and back. And I don't have the exact date of the last voyage.
Concernant l'embargo que le ministre lui-même vient de mentionner, pendant sa visite en île Rodrigue, le ministre avait mentionné qu'il allait enlever l'embargo sur l'importation de bétail à Rodrigue. Donc, est-ce qu'il peut nous dire si oui ou non il va considérer enlever l'embargo sur l'importation de bétail à Rodrigue?
I reiterate that it was partially lifted in January 2022, Mr. Speaker, sir. Now, concerning the complete lifting of the restriction, it will depend on the vaccination program against foot and mouth disease, followed by a sero-surveillance exercise. I wish to point out that the foot and mouth disease prevalence is estimated at around 10% right now in Rodrigue, and there is a third vaccination program which is ongoing since last month, that is June 2023, and one vet officer has moved from Rodrigues to help the 2 veterinary officers in Rodrigues for the said vaccination program. Once this vaccination program will be completed, a sero-surveillance will be done. In the light of the result of the sero-surveillance, then a decision will be taken whether to completely lift the restrictions or not, depending on the results.
Yeah.
Yes, B1100.
Mr. Speaker, I'm informed that as at date, there are 316 medical practitioners whose services are retained by the Ministry on a sessional basis for a duration of 1 year, renewable for another period of 1 year on the basis of satisfactory performance, conduct, and upon mutual agreement.
Yes, Mr. Speaker, the contract of 200 doctors has expired since 28th of May this year. But they are continuing to work and prescribe, including dangerous drug. May I ask the Honourable Minister, if ever there is a case of medical negligence, who will bear the responsibility? Is it the doctor or your ministry?
Well, since they are you as you have rightly said, so they are working. Needful is being done to renew their contract, but I have been told that they have made representation before the Conciliation and Mediation Division of the Ministry of Labour. And we are waiting for the outcome of the report, but at the same time, we are trying to get information from the SLU to clarify all matters, and letter will be sent to them. So since they are working, they are under the, everything is being looked at by the ministry.
Yes, Mr. Speaker, it seems that it's a recurrent feature at the ministry. That is the last time the contract was renewed. It was renewed after 6 months that the last contract was renewed. And doctors will the Honourable Minister agree with me that this situation, that a doctor has to wait for 6 months for his contract to be renewed, is a humiliating one, because they are doing a noble job, and also it's also tantamount to an infringement to labour laws.
I don't agree with Honourable Member, because I have been told that out of the 316 medical practitioners, 72, the contract of 72 medical practitioners have already been renewed in January and February 2023, and offer of employment for at least 10 medical practitioners will expire in August, September, and October this year. I agree with you that there are some 234 medical practitioners whose contract have expired, but as I have said, we are looking into the matter, and I'm sure that needful will be done in the months to come.
Next question.
Je vous remercie, Monsieur le Président. B1101.
Mr. Speaker, sir, I am informed by the National Children's Council that there are presently 38 child caregivers working on a roster basis at the Cap Malheureux Relay Shelter instead of 43, as mentioned by the Honourable Member. I am further informed that the number of residents admitted thereat as at date stands at 20. I wish to inform the House that there are actually 14 caregivers who are suspended. Moreover, the National Children's Council was previously managing the Notre Dame Relay Center, and since the 14th of June of this year, the management of that shelter has been handed over to an NGO. 13 caregivers who were working over there have been redeployed at the Cap Malheureux Relay Shelter, and consequently the services of these child caregivers have been retained in order to consolidate the existing workforce. Mr. Speaker, sir, according to the National Children's Council, in addition to the normal duties performed, the caregivers are also called upon to accompany and take care of a child who's been admitted in hospital round-the-clock basis, to work with residents with serious behavioral problems on a one-to-one basis, to cater for those who are on vacation, sick leaves, or casual leaves. And since the number of residents fluctuates constantly, Mr. Speaker, so the services of these caregivers are required in order to maintain a child-to-child caregiver ratio. Thank you.
Je vous remercie, Monsieur le Président. La ministre peut-elle indiquer à la Chambre si cette situation de sureffectif chronique du personnel découle d'une planification lourdement défaillante lors du transfert de gestion de l'abri de Notre-Dame à une ONG il y a plus d'un mois?
Mr. Speaker, sir, not at all to be putting it like this, because I have just explained in my main answer that there is a child-to-child caregiver ratio that has to be respected. The duties of the caregiver is not limited to a two-line scheme of service. It is a very extensive list of services that are delivered to the residents of the Cap Malheureux or any other residential institution for that matter.
Je vous remercie, Monsieur le Président. J'ai bien écouté la réponse de la ministre, mais je maintiens, je suis en possession du roster de Cap-Malheureux, et je maintiens qu'il y a une situation de sureffectif chronique dans ce shelter. Puis-je demander à la ministre de fournir des éclaircissements sur la décision de ne pas déployer le personnel de l'abri de Notre-Dame vers d'autres départements ou services au moment du transfert de la gestion à une ONG, étant donné, écoutez bien, que le sureffectif a un impact négatif sur les enfants placés. Merci, Monsieur le Président.
No, Mr. Speaker, sir, once again, the honourable member is not correct in what she's purporting in the House. I have just, and I reiterate, like you maintain, I maintain too, that the caregiver ratio to children at the moment at Cap Malheureux Release Shelter is adequate, and they are fulfilling what is required of them. Any policy or any decision of redeployment of those caregivers is not going to come from one of your recommendations. We have at the level of the ministry capable officers who are in charge of a specific unit, which is the child development unit of the ministry. Those shelters are run by the National Children's Council. The decision to redeploy or reallocate any caregiver or any human resource, as we say, will be up to them. And they will be very well-informed decisions as well. Thank you.
Next question.
Thank you, Mr. Speaker, sir. B1102.
Mr. Speaker, sir, I'm informed by the Land Drainage Authority that the project for the residential morcellement at Société Vallée des Sainte-Croix is located upstream of Vallée de Cauny, which has been declared as high-risk flood-prone area. I'm also informed that a letter of intent was granted by the then Minister of Housing and Land on the 8th of June 2018 to the Société Vallée des Sainte-Croix for subdivision of a portion of land of approximate extent of 93,000 meters square into 78 lots plus one green space. The proposed morcellement was overlain over the existing GIS data set available at the Land Drainage Authority, namely the digital elevation model and the natural drainage path. The said site is found to be crossed by several natural drainage paths. The site downstream of the proposed morcellement has been impacted during the past flooding events, whereby it was observed that clearing of the subject morcellement site at Vallée des Sainte-Croix has obstructed the natural drainage path, and the Land Drainage Authority has informed the Municipal Council of Port Louis accordingly. Mr. Speaker, sir, in a letter dated 13th of April 2023, the Minister of Natural Infrastructure and Community Development, National Development Unit, had informed my ministry that the morcellement project at Vallée de Cauny will disrupt the natural drainage system and accentuate the flooding downstream, and as such, the government has taken the decision to put on hold the morcellement project in that region. Subsequently, my ministry has, on the 20th of April 2023, instructed the Municipal City Council of Port Louis not to issue any building and land use permit for the said morcellement until further notice. However, as per the Land Drainage Authority, the natural drainage path has not yet been restored by the promoter. Mr. Speaker, sir, with regard to Part B of the question, I'm further informed by the Municipal Council of Port Louis that the application for 11 permits has been received for the specific region, and no building and land use permit has been issued in line with instruction from the Ministry of National Infrastructure and Community Development.
Thank you, Honourable Minister. I have received numerous complaints from inhabitants of that, not inhabitants, but future inhabitants of that region who have invested a lot of money for that plot of land, and they have been inquiring and waiting for an answer as well. May I request the Honourable Minister to kindly advise what's the way forward, that what is he proposing as the Minister towards those inhabitants of that region? Thank you.
Actually, it depends on the, is the work that's the remedial work that has to be done by the promoters. And when the remedial work is acceptable to LDA, then I think we can reconsider afterwards. But until this work are not done, it's a bit difficult to reconsider the issuing of the permits now.
Put question.
Yes, one last question to the Honourable Minister. Can you just, Honourable Minister, confirm to the House that no reinstatement work has been done following the different site visits and the different reports of the LDA?
That's what I've been told. Yes.
Next question.
B1103.
Mr. Speaker, sir, the National Infection and Prevention Control (IPC) committee was set up in May 2021. The main objective of the National IPC Committee is to provide strategic guidance and directives on infection prevention and control activities to ensure that the risks caused by transmission of preventable infection is minimized. In 2022, a national action plan on IPC was written in collaboration with WHO to address the gaps that were identified. Mr. Speaker, so assessment on IPC is carried out as follows: by the National IPC Committee twice a year, March, December, by the World Health Organization once yearly, July. In 2021, the National IPC Committee carried out assessment 4 times, with mean score at 64%, while the WHO carried out the assessment on 2 occasions, with mean score at 62%. In 2022, the National IPC Committee undertook the assessment thrice, with mean score at 68%, and the WHO obtained a mean score of 78% during its assessment. In 2023, the National IPC Committee carried out an assessment in March 2023, and the mean score was 59%. The assessment by the WHO is in progress. Mr. Speaker, sir, I'm informed that according to the national checklist, the IPC score of each hospital in March 2023 was as follows: 63% at Dr. Bruno Chong Hospital, 63% at Jawaharlal Nehru Hospital, 48% at Victoria Hospital, 72% at Dr. AGG2 Hospital, and 52% at Sir Sivasagar Ramgoolam National Hospital.
Thank you, Mr. Speaker, sir. The Honourable Minister mentioned about an IPC committee, national committee. May I ask him to clarify whether there is an IPC department with dedicated team within his ministry to assess the IPC targets and measures?
Yes, Mr. Speaker, sir. So you have the National IPC Committee and the Regional IPC Committee. So the National IPC Committee, the members, what is their task is to set a plan and relevant objectives in keeping with IPC, develop and regularly update IPC guidelines, and to review and approve IPC policies, develop a system to monitor infection control, coordinate continuous training, ensure access to products essential to IPC, review epidemiological surveillance data, coordinate outbreak investigations, and communicate and cooperate with other committees. So this is a national IPC. It is chaired by the Director of Health Services and the Director of Health Services, co-chaired by the Deputy Permanent Secretary and all the different directors of the ministry. And then the Regional IPC committee is at the hospital level with the regional health director and the nursing administrators and so on.
Mr. Speaker, sir, IPC is all about infectious diseases. May I know from the Honourable Minister how many infectious disease medical specialist doctors are employed by his ministry?
Mr. Speaker, sir, the ministry has only one specialist in infectious and control specialist in this service. But this control of infection is dealt at all, in the different staff, be it from the nursing staff, from the doctors working in the wards, from the nursing officers working in the operation theater, in the ICU, in the IPC. So it doesn't mean that you need to have many specialists in infectious control, but you need to train all grades of staff for infection control.
Next question.
B1104.
Mr. Speaker, sir,
At the very outset, I wish to inform the House that the last salary review exercise was undertaken at the Financial Services Commission in 2016. The next report was due in January 2021. I am informed by the FSC that following a procurement exercise launched in January 2022, a salary commissioner was appointed on 3rd of June 2022. The terms of reference of the salary commissioner included the following: A, to conduct a review of the existing salary and terms and conditions of employment; B, to carry out a review of the existing employee handbook and code of conduct; and C, to provide recommendations with respect to review of organizational structure, including manpower plan. Mr. Speaker, sir, I am also informed that the Salary Commissioner started the review exercise on 22nd June 2022, and all staff had the opportunity to make their representations. The Salary Commissioner submitted his report to the Board in March 2023. The report was considered at the level of the Board over several meetings. The report was due in January 2021, and the review in the salary would have considered the loss in purchasing power up to 2020, which would have amounted to 14.65%. However, the Salary Commissioner recommended to include the loss of the purchasing power of 2022. The loss of the purchasing power up to 2022 was computed at 27.03%. Consequently, the recommendation of the Salary Commissioner was to grant an increase of 23.67%, taking into consideration the government compensation of 3.36%, which was already paid up. Hence, all staff on substantive capacity will be granted an increase of 23.67%. The final version of the report was approved by the Board of FSC on 22nd June 2023, and the process is still ongoing administratively. Mr. Speaker, sir, I am also informed by the FSC that the report on the revised salary and terms and conditions of employment have been imparted to the staff on 29 June 2023. The staff were invited to accept the report through an option form with a deadline of 12 July 2023. At the expiry of the said deadline, save and except for one staff, all staff have exercised the acceptance of the report.
Thank you. I understand that the Honourable Minister is not the substantive minister, but will he consider tabling a copy of the report of the Salary Commissioner?
Mr. Speaker, sir, in my reply, I said that the report was approved by the Board on the 22nd of June, and the process administratively is still ongoing. So it is not proper to table any report as they have not completed the whole process at the level of FSC.
One last question. One of the main problem which the staff had with the report is that it was to take effect from January 2023, whereas the Honourable Minister himself mentioned that the review was due as far as back January 2021. So I know from the Honourable Minister, who I know is not the substantive minister, whether this question as to the date of application of the report has now been resolved between management and the staff?
Sir, Speaker, sir, I have also asked some information on this particular topic raised by the Honourable Member, and as I mentioned that once the report was approved by the Board and that the process is ongoing, these are the discussions happening to finalize the effective date of the report, and I'm sure once it is done, my colleague the Minister could eventually answer the Honourable Member.
Next question.
B1105.
Mr. Speaker, sir, the Medical Negligence Standing Committee has been constituted in June 2020 to carry out preliminary investigations into cases of alleged medical negligence in public health institutions. The objective of the MNSC is to expedite matters and to ascertain as to whether there has been any act of medical negligence during medical treatment and hospitalization of a patient. Mr. Speaker, I am informed that since the constitution of the MNSC in June 2020, a total of 138 cases have been investigated. For the period 2022 to June 2023, a total of 68 cases have been investigated by the MNSC. Out of the total of 138 cases investigated, the MNSC has concluded that 37 cases need to be referred to the Medical Council of Mauritius and Nursing Council for further investigation and appropriate actions as deemed necessary. Following the investigation at the level of the Medical Council of Mauritius, 19 cases have been set aside, 5 cases have been referred back to my ministry, 1 case has been referred to the Medical Disciplinary Tribunal, 1 warning and 6 severe warnings have been issued, 1 suspension has been effective, and 4 cases are still under investigation. Disciplinary actions are taken by the Public Service Commission following recommendation of the statutory bodies through which delegation of powers is entrusted as per PSC regulations. With regard to Part C of the question, I am informed that the 138 cases investigated by the MNSC pertain to the departments of obstetrics and gynecology, pediatrics, general surgery, and orthopedics.
Monsieur le Président, les négligences médicales ont des conséquences graves comme perte de vie ou séquelles permanentes. Je demande donc à l'honorable ministre si son ministère a une stratégie pour réduire et protéger la population contre ces négligences médicales parce que le nombre ne baisse pas au fil des années, qui démontre clairement que la stratégie actuelle ne marche pas.
Mr. Speaker, sir, in regard to whether the number of cases referred and whether number of cases that have medical negligence has been going up since the last few days, in fact, it has been going down. And the number of cases that with proved medical negligence has been going down for the last 3-4 years. Now, the question is, what is the strategy? Obviously, the strategy would be how we improve the service delivery in terms of so many issues, in terms of capacity building, in terms of IT, information and technology. So these being undertaken at the pace, and obviously with time we will have different services, but that takes quite some time to improve on all the different aspects so that we can get a better service in the public health sector.
Next question.
B1106.
Mr. Speaker, sir, in regard to the consumption of illicit drugs, the number of young persons under the age of 20 admitted in public hospitals and residential drug treatment and rehabilitation centers since January 2020 to June 2023 is 479. That is 444 males and 35 females. In public hospitals, 300 admissions, that is 272 males and 28 females have been recorded from January 2020 to June 2023 in regard to consumption of illicit drugs for this age group. For the same period, the number of admissions for males in residential drug treatment and rehabilitation centers are as follows: 100 at Nénuphar Center, Montaillon, 36 at Mayberg Detoxification and Rehabilitation Center, 36 at Frangipan Center, which is operation since July 2021, and with regard to female patients, 7 were admitted at the Centre Orchidée, which became operational in July 2022. Mr. Speaker, sir, with regard to Part A of the question about treatment provided substance use disorder patients in centers of the harm reduction unit are seen by a multidisciplinary team comprising of doctors, specialized nurses, psychologists, psychiatrists, and also non-governmental organizations and social workers to ensure their holistic management. The medical management of substance use disorders patients is tailor-made to the need of each patient. Different treatments available in our hospital centers are as follows. Detoxification with Suboxone in the context of Suboxone naltrexone treatment, methadone substitution therapy program, and addressing comorbidities related to substance use disorders like HIV infection, hepatitis infection, sexually transmitted diseases, and psychiatric comorbidities are also addressed. All these programs are in line with the protocol de prise en charge de l'usage de drogue, which is in place since March 2023. Mr. Speaker, sir, patients also undergo psychosocial management and rehabilitation, which encompasses the following: a systemic preparation to stay for treatment and other routine activities contributing to successful rehabilitation, including daily hygiene, physical exercises, indoor games, literacy and numeracy exercises, creative arts, counseling activities, psychosocial support, agriculture and gardening, and relapse prevention sessions. After treatment and care at regional hospitals and related centers, the follow-up of patients is carried out at the regional hospitals and methadone daycare centers and addiction treatment units thereafter. Mr. Speaker, sir, in regard to Part B of the question, about remedial actions for this target group, the following measures have been taken by my ministry. First, drug use prevention activities in line with the National Drug Control Master Plan 2019-2023. Prevention is carried out in educational and training institutions, the community, including correctional youth centers and rehabilitation youth centers, and the workplace. 2, the national mass media, social media campaign is carried out targeting adolescent and young adults. 3, the youth empowerment program against drug launched in 2021. 4th, the setting up of a drug users administrative panel in order to give the population, including young users, an opportunity to rehabilitate and reintegrate mainstream society.
Oui, Monsieur le Président, selon un rapport du Bureau de l'audit intitulé Enhancing the Effectiveness of Interventions Related to Drug Demand and Harm Reduction datant d'avril de cette année, mention est faite que plus de 150 jeunes de 15 à 19 ans sont admis chaque année dans les hôpitaux pour des complications liées à la consommation de drogue. De ce fait, le ministre peut-il nous dire quelle est la stratégie, à part de ce qu'il a mentionné dans sa réponse initiale, que son ministère a mis en place pour aider ces jeunes à sortir de cet enfer et pour ne pas rechuter à l'avenir?
Mr. Speaker, sir, so the different treatment and different program being proposed as already mentioned. Now the question is whether we have to redevise another strategy. So this master plan, the National Drug Control Master Plan 2019-2023 will be having a new master plan, and in that master plan we're going to see again what's happening in terms of the people who use drugs, intravenous drugs, and then we can have another strategy for the next 5 years.
Monsieur le Président, au niveau des jeunes de 14 ans, dans ce même rapport, on fait état que de 7 admissions par an par rapport aux jeunes de 14 ans. De ce fait, le ministre peut-il nous dire ce qui est fait actuellement par son ministère pour inverser cette tendance, cette situation, surtout que le rapport du Bureau de l'audit a fait un constat d'échec du programme Get Connected, pourtant implanté dans 24 écoles secondaires.
Mr. Speaker, sir, this we have to look at it again with the different stakeholders, Ministry of Education and the National Secretariat Against Drugs, this or the NDS also. We have to work it again, and then probably I will be able to give an appropriate answer on this.
Next question.
Next question.
Next. No supplementary, next question.
No supplementary.
B/1107.
Mr. Speaker, sir, I thank the honourable member for having asked this question, which I'm sure will help me to enlighten the House on this issue. The Convention on Cluster Munitions is a legally binding international treaty that prohibits the use, the production, the transfer, and the stockpiling of cluster munitions in accordance with human rights and humanitarian law. The commonest type of cluster munitions is air-dropped or ground-launched explosive weapons that eject explosive bomblets that kill indiscriminately over a wide area and are known to linger unexploded for years and then suddenly detonate, causing life loss and injury to civilians and infrastructure alike. Certain cluster munitions can disperse chemical or biological weapons. Sir, the Convention on Cluster Munitions entered into force on the 1st August 2010. To date, the Convention on Cluster Munitions has 111 state parties and 12 signatories. The USA, Ukraine, and the Russian Federation are neither party nor signatory to the Convention. Mauritius deposited its instrument of accession to the Convention on the 1st of October 2015. Accordingly, the Convention entered into force for Mauritius on the 1st of April 2016, pursuant to its Article 17.2. Mauritius, therefore, is a state party to the Convention on Cluster Munitions. The Convention on Cluster Munitions has been incorporated into Mauritian law through the Anti-Personnel Mines and Cluster Munitions Prohibition Act of 2016. The law strictly prohibits cluster munitions, among other lethal weapons, and provides for hefty punishment for offenders. The law also provides for extraterritorial jurisdiction by Mauritian courts where the alleged offence has been committed outside Mauritius and that the person to be charged of the offence is either a natural or legal person of Mauritian nationality, or where the offence affects any natural or legal person in Mauritius. Mr. Speaker, sir, Mauritius is among those countries that enforce a complete ban on cluster munitions by virtue of being a state party to the Convention on Cluster Munitions. It is also the result of our adherence to a human rights approach to address the humanitarian consequences and unacceptable harm to civilians caused by cluster munitions. Mauritius, therefore, subscribes to a complete prohibition of such weapons that cause excessive victims, including among civilian populations and infrastructure. We recognize, sir, that disarmament is an essential part of conflict prevention and is paramount to achieving lasting peace. Therefore, Mauritius will continue to work with like-minded countries and the Secretariat of the Convention in Geneva to sensitize stakeholders and non-state parties to the Convention against the use of cluster munitions in any military conflict and to resolve all disputes in a peaceful manner and in accordance with established norms. We also follow closely the work of the Secretariat of the Convention for the universalization of the Convention, the surest way to achieve a world ban on cluster munitions. Mr. Speaker, sir, in the light of the foregoing, Mauritius is against the use by any party of cluster munitions at any time and anywhere and in any circumstances. Accordingly, we call on all countries, whether or not signatory to the Convention on Cluster Munitions, not to frustrate the aims and objectives of the Convention and to be compliant with international humanitarian law. Accordingly, sir, Mauritius deplores the transfer of any such weapons to a third party for eventual use by the latter. Thank you.
Thank you very much, Minister. I subscribe to the comprehensive reply given by the Honourable Minister. But can I ask him whether he had it, well, of course, we all express our deep-seated concern, whether he had meetings with the Russian ambassador and with the US ambassador to express our deep-seated concern, notwithstanding the fact that we are working with like-minded countries, of course.
Mr. Speaker, sir, I have said, I think the answer to the honourable member's question is already found in the answer to the question. I have already replied, in fact, to this question, Mr. Speaker, sir. I will repeat. The stand of our country is that we call on all parties not to use such weapons in any circumstances, including whether against a foreign country or within one's own territory or in any occupied zone of one's own territory. In fact, Mr. Speaker, sir, we have gone far enough also because the call of Mauritius is with regard to the conflict in Ukraine has been that all parties should renounce the use of cluster munitions, which, as I just said, is an internationally banned weapon, and both countries should accede to the Convention on Cluster Munitions. This is our call, Mr. Speaker, sir. Cluster munitions stockpile should have been declared and destroyed, and must be destroyed as soon as it is safe to do so, and international support must be given to enable clearance efforts. Mr. Speaker, sir, our call also goes in the direction that governments worldwide should continue to condemn the use of these munitions in Ukraine and elsewhere, and call for all states to join the the Convention on Cluster Munitions.
Minister, you forgot that I was also Minister of Foreign Affairs. I'm not asking that we have to punch above our weight. I have a specific question. Did you have a meeting with the ambassador of US and the ambassador of Russia to express our deep-seated concern?
Well, Mr. Speaker, sir, I have just said that the stand of Mauritius is that we are not only a state party to this convention, we have also incorporated... Let me finish.
Order.
We have...
What is happening?
We have also...
Who are you, Ambassador?
We have also domesticated this convention. We have incorporated it in our law since 2016, Mr. Speaker, sir. So the stand of Mauritius is very clear with regard to this convention and with regard to the parties involved in the conflict.
Thank you, Mr. Speaker, sir. In his reply, the Honourable Minister informed the House that USA, Russia, Ukraine are not signatory of the convention, but can they act regardlessly under the cluster munition?
Order. Order.
Mr. Speaker, the answer to this...
Honourable Toussaint, what is happening?
Mr. Speaker, the answer to this question is that regardless of whoever has joined the Convention on Cluster Monitoring, the rules of international humanitarian law must be respected. Regardless of whether you're a state party or not, the rules of international humanitarian law must be respected by all parties to any armed conflict, Mr. Speaker, sir. In fact, media reports are to the effect that Russia has been using these weapons since the beginning of this military conflict in Ukraine. But media reports also are to the effect that Ukraine has also used its own ex-Soviet stockpile of cluster bombs. But the nature and the characteristics of these weapons, Mr. Speaker, sir, as I have just said, is that they can, these weapons can scatter tens or hundreds of explosive sub-munitions over a wide area, and these sub-munitions do not explode on delivery, but they are left sinking in water, in muddy areas, or in soft ground, and can explode years or decades after, and can be injure or maim children or civilians who can come and pick up these munitions, Mr. Speaker, sir. This is why, adhering to the rules of war, there's a principle called the rules of war, which is strictly required, Mr. Speaker. These rules are in fact designed to balance military necessity and humanitarian considerations, Mr. Speaker. The use of such type of weapons, in fact, breaches international humanitarian law. This is the answer to the honourable member's question, because the use of these weapons, Mr. Speaker, sir, in fact, breach two principles: the principle of distinction, which upholds the need in an armed conflict to distinguish between combatants, soldiers, and civilians, and also another principle called the principle of proportionality, which upholds the rule of indiscriminate attacks. Mr. Speaker, sir, having said this, let me just finish on one point. According to me, Mr. Speaker, sir, by way of the declaration of President Biden on the 7th of July at the NATO summit, we all are conscious or aware of what declaration I'm referring to. In fact, the US on that day sent a very poor message to the world, especially to countries who are not yet parties to the convention. But fortunately, the declaration of President Biden did not erode the fundamental value and importance of this convention. Mr. Speaker, sir, any modern nation using cluster ammunition loses its moral leadership under international humanitarian law and practices.
Honourable members, the following questions have been removed, withdrawn. Can the acting clerk bring the list of questions which has been withdrawn? B1109, B1113, B1116, B1121, B1133. Time over.
Mr. Speaker, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded. The question that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye, those against say no. Aye. Ayes have it.
Statements by ministers none. Public bills first reading.
Mr. Speaker, sir, I move that the Private Recruitment Agents Bill number 12 of 2023 be read the first time.
Seconded.
Public bill second reading.
Mr. Speaker, sir, I move that the finance Mr. Speaker, sir, I move that the Finance Bill number 11 of 2023 be read a second time. The Finance Bill number 11 of 2023 provides for the implementation of measures announced in the budget speech 2023-2024 and its annex, and for matters connected, consequential, or incidental thereto. The bill brings amendment to 90 enactments, which cover the three themes of the budget, namely strengthening the foundations of our economy, continuing the transformation of Mauritius into a sustainable economy, and the future we deserve. Mr. Speaker, sir, the main amendments contained in the bill will be explained. I will now speak on the main amendments which relate to the strengthening the foundations of our economy. Clause 2 amends the Advertisement Regulations Act to provide that the fee payable on an advertising structure will be reduced by half as from 1st January 2024. Clause 3 amends the Allied Health Professional Councils Act to provide inter alia for a representative of the ministry responsible for the subject of finance to be a member of the EHPC, and application for registration as an allied health professional to be considered as approved in case the AHPC does not determine the application within 30 working days. Clause 6 amends the Asset Recovery Act to impose the requirement of keeping documents beyond the prescribed timeline in cases where a restraining order or restriction order has been granted, and exempt the Asset Recovery Investigation Division of the Financial Intelligence Unit from payment of any duty, tax, or registration fee pertaining to seizure of assets. Clause 8 amends the Bank of Mauritius Act to clarify that transfers from the Special Reserve Fund are no longer warranted. Clause 9, 43, and 45 amends the Banking Act, Landlord and Tenant Act, and Mauritius Cane Industry Authority Act, respectively, to replace the term repo rate by key rate in the context of the implementation of the new monetary policy framework. Clause 12 amends the Civil Aviation Act to increase the passenger fee with effect from 1st January 2024 and applicable fines for offences made under the Act. Clause 14 amends Clinical Trial Act to, amongst others, review the composition of the Clinical Research Regulatory Council and provide for the determination of an application for clinical trials within 30 working days. Clause 15 amends the Companies Act to, amongst others, provide that listed companies shall have a minimum of 25% of women on their boards to promote gender equality. Require a company to send its annual report to shareholders at least 21 days instead of 14 days prior to the annual meeting, and enable a company to send its annual report and financial statements electronically, coupled with the right for shareholders to request for a hard copy of the documents. Clause 16 amends the Construction Industry Development Board Act to inter alia exempt foreign contractors and consultants from the requirement of subcontracting to local firms in cases where no local consultant or local contractor has the necessary experience or expertise. Clause 22 amends the Dental Council Act to inter alia review the composition of the Dental Council and provide for application for registration to be considered as approved if the application is not determined within 30 working days. Clause 24 amends the Economic Development Board Act to, amongst others, allow professionals from all sectors to be granted occupation permit provided that they draw a monthly basic salary of at least 30,000 rupees. Provide for the establishment of a national contact point under the EDB in line with OECD guidelines for multinational enterprises on responsible business conduct. Open the young professional occupation permit to all fields of study and enlarge the objectives of the Premium Investor Scheme with a view to allowing the implementation of projects under an environment, social, and governance framework. Clause 29 amends the Finance and Audit Act to provide for inter alia statements to be prepared by the Rodrigues Regional Assembly in line with IPSAS. Clause 31 amends the Financial Intelligence and Anti-Money Laundering Act to exempt the FIU from payment of registration duty or fee in respect of any document signed or executed by the FIU. Clause 32 amends the Financial Services Act to, amongst others, empower the FSC to take enforcement actions in case of breach of AML-CFT legislation, provide that the FSC can enter into arrangements and extend assistance to a foreign supervisory institution, provided that confidentiality requirements are met, enhance the role of management companies with respect to ensuring compliance of their clients with relevant laws, and provide for the electronic filing of documents by licensees. Clause 34 amends the Freeport Act to add minting and refining of precious metals as new Freeport activities. Clause 30 amends the Finance Act 2021 to facilitate the winding up of the Fishermen Investment Trust. Clause 37 amends the Immigration Act 2022 to, amongst others, allow for the young professional occupation permit to be opened to all fields of study, allow a non-citizen and his family to be granted a residence permit on the acquisition of property of a minimum price of $375,000 USD under the Sustainable City Scheme, and grant a residence permit to a retired non-citizen and his family on the acquisition of a property in a property development scheme project relating to senior living. Clause 39 amends the Independent Broadcasting Authority Act to allow foreign investors to invest in companies holding a subscription television direct-to-home satellite broadcasting and rebroadcasting license. Clause 40 amends the Insolvency Act to inter alia clarify that a liquidator cannot set aside any transfer from an insolvent party to a non-insolvent party unless there is a clear and convincing evidence that the insolvent party made the transfer to defraud the entity to which the insolvent party was indebted. Clause 41 amends the Insurance Act to enable the Insurance Industry Compensation Fund to provide for appropriate non-pecuniary assistance to victims of hit-and-run road accidents. Clause 42 amends the Land Act to, amongst others, reintroduce the arrears payment scheme for another year. A debtor will benefit from the full waiver of interest and penalties if he settles his debt on or before 31st March 2024, and grant exemption of land transfer tax and registration duty on the transfer of immovable property from wellness-related activities, provided the company holds an investment certificate issued by the EDB. Clause 50 amends the Medical Counseling Act to inter alia review the composition of the Medical Council and provide for application for registration as a medical professional to be considered as approved in case the Medical Council does not determine the application within 30 working days. Clause 51 amends the Merchant Shipping Act to, amongst others, make it mandatory for the Director of Shipping to hold preliminary inquiry in case there is a loss of life, presumed loss of life, or serious injury to any person as a result of a shipping casualty, and empower the Director of Shipping to recover from the owner of a ship all government expenses incurred in respect of measures taken to prevent any damage to the environment or mitigate any hazards to safety of navigation. Clause 52 amends the Morcellement Act to exempt the Mauritius Investment Corporation Limited from the payment of processing and morcellement fee. Clause 49 amends the Meat Act to allow the Mauritius Meat Authority to, amongst others, purchase or import livestock for slaughter, resale, or slaughter and resale. Clause 53 amends the National Agricultural Products Regulatory Office Act to enlarge the definitions of tea and tobacco. Clause 58 amends the Non-Citizens Employment Restriction Act to make it mandatory for applications for work permit to be made on NELs, and introduce a silence is consent principle of 30 working days for the determination of applications for work permit. Clause 59 amends the Non-Citizens Act to review the criteria relating to sale of immovable property outside the scheme to resident non-citizens. Clause 60 amends the Nursing Counseling Act to, amongst others, review the composition of the Nursing Council and provide for application for registration as a nursing professional to be considered as approved in case the Council does not determine the application within 30 working days. Clause 62 amends the Ombudsperson for Financial Services Act to exclude financial services not licensed by the Bank of Mauritius and the Financial Services Commission from the purview of the Ombudsperson for Financial Services. Clause 65 amends the Port Act to increase the fines applicable when a person fails to comply with or contravenes any other provision of the Ports Act. Clause 66 amends the Private Pension Schemes Act to, amongst others, provide for settlement of unclaimed benefits by a beneficiary's assignee, legal heirs, or legal representative 7 years or more after death of the beneficiary, enable the FSC to maintain records of abandoned funds so as to ensure the refund of these funds to the legal representative as well if need arises, and introduce micro-pensions through the setting up of a private pension scheme targeting the informal sector. Clause 74 amends the Securities Act to enable funds to invest in loans or similar debt instruments. Clause 75 amends the Shooting and Fishing Leases Act to inter alia have better control on the biodiversity and ecosystem restoration activities, ecotourism activity, forest management activity, and agroforestry activity on leased state land. Clause 76 amends the Small Farmers Welfare Fund Act to enlarge the scope from small planters to small farmers. Clause 82 amends the Sugar Industry Efficiency Act to, amongst others, provide that a government entity undertaking a project in the national or economic interest of Mauritius on state land will not require land conversion permit to put the state land into non-agricultural use. Provide that applications for land conversion will have to be made on the national e-licensing system, and exempt the New Social Living Development Limited and the Mauritius Investment Corporation Limited from payment of the land conversion tax. Clause 84 amends the Tourism Authority Act to remove the restriction on the number of restaurants a hotel can have under a tourism accommodation certificate. Clause 85 amends the Variable Capital Companies Act to extend the scope of the variable capital companies to allow their use for family offices and wealth management. Clause 87 amends the Veterinary Council Act 2020 to inter alia review the composition of the Veterinary Council and provide for application for registration as a veterinary professional to be considered as approved in case the Council does not determine the application within 30 working days. Clause 88 amends the Virtual Asset and Initial Token Offering Services Act to, amongst others, allow a virtual asset custodian to also hold custody of securities token. Mr. Speaker, sir, I now come to the second theme, which is about continuing the transformation of Mauritius into a sustainable economy. Clause 7 amend the Ayurvedic and other traditional medicines Act to cater for specialists in traditional medicines. Clause 13 amends the Civil Status Act to inter alia empower the Central Civil Status Office to generate an NIC number for a child born in another country, provided that at least one parent is motioned. Give an additional period of 15 days to parents for the declaration of birth of their child, and share information with agencies for the discharge of their respective functions. Clause 23 amends the Early Childhood Care and Education Authority Act to, amongst others, enlarge the functions of the Early Childhood Care and Education Authority, including payment of grants to aided pre-primary schools in the context of the free pre-primary education scheme, and review of the composition of the board of the Early Childhood Care and Education Authority Board to include a representative of the Special Education Needs Authority. Clause 25 amends the Education Act to, amongst others, establish the framework for implementation of the free pre-primary education scheme and provide for 2 scholarships annually to the best performing candidates having opted for the HSE Professional National Scheme. Clause 33 amends the Firemen Act to inter alia reduce the time period for a holder of firearm license who intends to leave Mauritius to surrender any firearm and ammunition in his possession from 3 months to 2 weeks. Clause 46 amends the Mauritius Institute of Education Act to review the composition of the Mauritius Institute of Education Council and include the Director of the Special Education Needs Authority in the Academic Board of the MIE. Clause 47 amends the Mauritius Qualification Authority Act to, amongst others, empower the MQA to approve and recognize micro-credentials in technical and vocational education and training, and monitor the implementation of the National Credit Value and Transfer System in TVET under the National Qualifications Framework to facilitate mobility and lifelong learning. Clause 55 amends the National Identity Act to, amongst others, provide for the establishment of a national identity card unit to ensure proper functioning and administrative efficiency of the national identity card, and cater for the introduction of mobile ID as a new feature in the new Mauritius National Identity Card System. Clause 64 amends the Pharmacy Act to facilitate registration of locally manufactured products under a technology transfer agreement with good manufacturing practices of the World Health Organization. Clause 72 amends the Roads Act to introduce a fixed penalty system for persons who commit offenses under the Roads Act. Clause 79 amends the State Lands Act to inter alia provide for a reduced rental in respect of a socio-economic project implemented on state land leased by a statutory body or a government-owned company in which the government directly or indirectly holds at least 90% of the shared capital. Grant to a lessee holding an industrial or commercial lease and facing financial difficulty to pay annual rental for any particular year in not more than 3 consecutive equal yearly installments without interest, provided no dividend is distributed during that period. And grant a reduction in annual rental for a period not exceeding 5 years in respect of lease granted for any particular business activity. Clause 89 amends the Wastewater Management Authority Act to inter alia allow the Wastewater Management Authority to enter into an agreement with an approved entity for the purposes of implementation, management, and funding mechanism of wastewater projects and systems. Mr. Speaker, sir, I now will elaborate on the third theme of my speech, which is about the future we deserve. Clause 4 amends the Animal Diseases Act to, amongst others, include diseases listed by the World Organization for Animal Health in the definition of diseases. Clause 5 amends the Animal Welfare Act to, amongst others, review the composition of the Council, require a person to register his dog with Mauritius Society for Animal Welfare not later than 60 days after he becomes the owner, and empower EMSO, instead of the Division of Veterinary Services, to issue breeder's permit. Clause 17 amends the Consumer Protection Act to inter alia make it mandatory for traders with annual turnover exceeding 50 million rupees to submit information electronically to the Ministry of Commerce and Consumer Protection for the MOPRI application. Clause 19 amends the Customer Act to, amongst others, allow a right of appeal to an importer who imports goods on behalf of another person entitled to tax exemption and provide that the penalty provision applicable when an importer has not submitted a bill of entry for the clearance of goods within 5 working days after the time an aircraft has landed or a vessel is berthed will not apply until 30 June 2024. Clause 20 amends the Customs Tariff Act to inter alia exempt from the payment of custom duty any contractor engaged in the construction of social housing units by the new Social Living Development Limited, and provide for NGOs registered with the National Social Inclusion Foundation to be entitled to customs duty exemptions on a motor vehicle. Clause 21 amends the Dangerous Drugs Act to, amongst others, provide for an electronic drug register. Clause 26 amends the Employment Relations Act to inter alia provide that the Employment Relations Tribunal will have to make its order in cases of reinstatement within a period of 60 days instead of 90 days. Clause 27 amends the Employment Relations Act 2019 to, amongst others, provide for a wage grade for graduate to ensure that they are remunerated accordingly. Clause 28 amends the Excise Act to inter alia extend the negative excise duty scheme on electric vehicles up to 30 June 2024, exempt from the payment of excise duty any contractor engaged in the construction of social housing units by the new Social Living Development Limited, provide for NGOs registered with the National Social Inclusion Foundation to be entitled to excise duty exemption on a motor vehicle, and provide for an increase in the rate of refund payable for waste PET bottles recycled into reusable goods from 15 rupees per kilogram to 30 rupees per kilogram. Clause 35 amends the Gambling Regulatory Authority Act to inter alia empower the GRA board to issue warnings to its licensees in case of non-compliance with the GRA Act and conditions of license, rules, directions, or guidelines. Allow the Horse Racing Committee to provide for veterinary services in and out of competition, pre-race and post-race, sampling and testing of horses. empower the Gambling Regulatory Authority to issue directives in respect of interactive gambling sites outside Mauritius, and enlarge the duties of inspector to carry out money laundering, anti-money laundering, counter-terrorism inspections, and compliance audits. Clause 36 amends the Human Resource Development Act to reinforce the sustainability of the Workfare Program Fund. The contribution rate of levy remitted to the WPF will be aligned to that of the National Training Fund, that is at 0.75% for the period 1st July 2023 to 30 June 2025. Clause 38 amends the Income Tax Act to, amongst others, implement the holistic and progressive tax reform of our personal income tax system as from 1st July 2023, grant a double deduction in respect of emoluments paid to a woman employed under the Prime à l'Emploi scheme for a period of 2 years, and triple deduction in respect of emoluments paid to a disabled person. Allow taxpayers to deduct for their taxable income 10,000 rupees for each animal adopted from an NGO registered with the MRA up to a maximum of 30,000 rupees in an income year. Grant a company a triple deduction in respect of donations to a charitable institution involved in supporting persons with health issues and disabilities, protection or rehabilitation of street children, or animal welfare and protection. Grant to a company a double deduction in respect of the costs incurred for setting up a child daycare center. Extend the investment tax credit granted to manufacturing companies for up to 30 June 2026, and exempt from income tax interest income derived from bonds, debentures, or sukuk issued by an overseas entity to finance renewable energy projects. Clause 44 amends the Local Government Act to inter alia exempt a religious institution from payment of local rates on its halls and buildings. Clause 48 amends the Mauritius Revenue Authority Act to inter alia reintroduce the tax arrears settlement scheme, which provides for full waiver of penalties and interest where tax arrears are paid in full by 31st March 2024. Clause 54 amends the National Employment Act to ensure that real-time information is available on the number of registered job seekers who are willing to follow training and take up employment. Clause 56 amends the National Pension Act to inter alia extend payment of child allowance to all beneficiaries of basic retirement pension, provide for child allowance to be 2,000 rupees monthly, irrespective of age, and increase basic retirement pension, basic invalidity pension, basic widow's pension, and basic orphan's pension by 1,000 rupees monthly. Clause 57 amends the National Wage Consultative Council Act to provide that the Council may proceed with review of minimum wage before the prescribed period of 5 years. Clause 61 amends the Occupational Safety and Health Act 2022 to reinforce the safety and health standards at the workplace. Clause 63 amends the Pension Act to clarify that the death benefit for an officer who joined service on or after 1st January 2013 be deducted from total pension contributions paid. Clause 67 amends the Public Debt Management Act to introduce a public sector debt ceiling of 80% related to the fiscal anchor fixed by the IMF. Clause 69 amends the Public Procurement Act to, inter alia, introduce low-value procurement for goods, works, consultancy services, or other services not exceeding 500,000 rupees and cater for planning, pre-bidding, and post-award activities in the e-procurement system. Clause 70 amends the Registration Duty Act to, inter alia, allow for the levying of an additional registration duty of 10% on the acquisition by a non-citizen of an immovable property of at least 500,000 USD. Increase from 15 days to 28 days the time given to an aggrieved person to object to an assessment of the Registrar General following a transfer of a movable property, and extend the home ownership and home loan schemes up to 30 June 2024. Registration of Clause 71 amends the Registration of Associations Act to provide for the election of officers to be conducted at least once every 5 years. Clause 73 amends the Sale of Immovable Property Act to, inter alia, specify that where the sales property is the sole residence of the debtor, the mise à prix shall not be less than 90% of the open market value and 80% for a property other than the sole residence. Clause 77 amends the Social Contribution and Social Benefits Act 2021 to, amongst others, extend the payment of the CSG income allowance until June 2024, including end-of-year bonus. The amount of allowance payable is being increased to 2,000 rupees for individuals deriving income not exceeding 25,000 rupees and maintained at 1,000 rupees for individuals deriving income above 25,000 rupees but not exceeding 50,000 rupees. Introduce the monthly child allowance of 2,000 rupees for children up to the age of 3 years, and introduce the independence allowance of 20,000 rupees to an individual having attained the age of 18 years as from 1st January 2023. Clause 78 amends the Social Integration and Empowerment Act to provide for the increase in the household income threshold to qualify for eligibility under the Social Register of Mauritius. Clause 81 amends the Statutory Bodies Pension Funds Act to, inter alia, provide that an officer applied before 1st January 2013 and reckoning not less than 10 years pensionable service in statutory bodies be eligible to a portable benefit equivalent to at least 1 year pensionable salary. Clause 86 amends the Value-Added Tax Act to, amongst others, clarify that a VAT assessment should not be made in respect of a period beyond 4 years immediately following the last day of the taxable period. Provide for zero rating for VAT purposes of 15 key items of everyday consumption, musical instruments, apparatus used in medical, surgical, dental, or veterinary sciences, medical grade silicone, and glass ceramic blocks for dental use. Extend the VAT exemption on the construction of a building for primary and secondary education, and exempt from the payment of VAT any contractor engaged in the construction of social housing units by the New Social Living Development Limited. Clause 90 amends the Workers' Rights Act to, amongst others, provide for more flexible working arrangement by authorizing a worker to complete his normal working hours in a week on 4 days, provide for payment of the special allowance to public officers to guarantee them a monthly income of 15,000 rupees as from 1st July 2023. Provide that a worker may opt that his untaken annual leave be accumulated instead of being refunded. Provide that a worker may avail of his entire leave's entitlement to care for his child and 10 days of his leave entitlement to care for his parents and grandparents. Provide that in addition to the 3 weeks leave, a female worker who suffers a miscarriage be granted another 5 days leave on full pay. Provide that an employer having more than 250 workers shall provide free of charge child care facilities to a worker having a child aged up to 3 years, and provide that the 10% increase in petrol allowance shall, as from 1st July 2023, be between 1,000 rupees and 2,000 rupees. Clause 91 amends the Workers' Rights Regulation 2023 to provide for a revenue minimum guarantee of 15,000 rupees monthly as from 1st July 2023. Mr. Speaker, sir, I'm proposing amendments at committee stage to the Bank of Mauritius Act, Economic Development Board Act, Employment Relations Act 2019, Income Tax Act, and Local Government Act. These amendments are being circulated in the House. I now commend the bill to the House.
Honourable members, before we proceed with the debate, I wish to draw the attention of honourable members that in March 2015, an amendment was brought to Standing Order 52 by adding paragraph B, and I quote, "A finance bill may, in addition to the measures relating to taxation and national finance announced in a budget speech, contain provisions relating to the other measures announced therein and provide for matters connected, consequential, or incidental to those measures." Keeping with past practice, the Ministry of Finance, Economic Planning and Development has worked out explanatory notes on the provisions of the Finance Miscellaneous Provisions Bill 2023 for ease of reference of honourable members to the relevant paragraphs of the budget speech and the annex thereof to which the amendments relate, and same has been circulated to honourable members on Wednesday last, together with the existing legal provisions. Moreover, your kind attention is also drawn to the provisions of Standing Order 42.1 in regard to relevancy in debate. Honourable members, in the light of the above, honourable members are expected to confine their observations to the proposed amendments contained in the Finance Miscellaneous Provisions Bill and should not open the debate on policy matters which have already been canvassed during the second reading of the appropriation bill. In view of the technicality of the amendments, I appeal to honourable members to kindly indicate the clauses on which they are offering their observations for the orderly conduct of the debate. Honourable members are invited to kindly stand guided accordingly. Thank you.
Mr. Speaker, I'm well aware of the usual practice concerning debates on finance bills. I must say that this finance bill proposes to change or amend 90 laws, and the Office of the Clerk has kindly submitted the clauses that will be amended. So for the benefit of yourself and the public, you will see that in this 1 week, we've had to consult this book, which we'll use afterwards to stop the door from closing in my house. This is the work that we have had to do for the last week, Mr. Speaker. Now, it is of huge regret, that many of the issues that are many of the laws that are being changed today were not canvassed, discussed, introduced during the speech of the Honourable Minister of Finance at the budget time. this may be, Mr. Speaker, is what you could have reminded him, is that the usual practice is for either the finance bill, the changes to be introduced during the budget speech so that we can debate them during the budget speech, or at least in the annex. But I'd ask you, perhaps you can help me. I wondered, where on earth did the minister tell us that he was going to amend the Bank of Mauritius Act? Important issues, very important issues. Never. So we will need to deal with policy issues on quite a few of the items because they have not respected usual practice. And the same will go as far as the Public Debt Management Act. Not introduced anywhere. It comes with this book, Mr. Speaker. And even the explanatory notes. Many of these notes, in fact, they just bypass the important issues in this clause, guiding you to some silly amendment, whereas, in fact, if you look at it properly, you will see that the explanatory note ought to have guided you on the real issue of the clause being amended. So that was what I had to say, Mr. Speaker. I'm sad that we have to say this. I would have hoped that we would have kept with previous practice. I was Minister of Finance myself, that most, or not all, of the budget of the finance bill had already been presented during budget speech or annex, and one or two exceptions obviously arise. But this is not the case. Now, I will restrict myself to about 12 issues which I think are important. The other members of the opposition will no doubt raise a few others where we have no chance, no hope of ever covering everything that needed to be covered. And don't blame us, anyone, if we've missed something important, because we are human beings and we cannot deal with 90 amendments and this book in one speech, Mr. Speaker, sir. Now, I want to deal firstly with the removal, what the minister just said just now. I'm a bit surprised. He said that clause 8 of the bill does away now with transfers from the Special Reserve Fund to government because they are no longer warranted. But that is not the case. That is not true. That is not true. I refer the Honourable Minister to clause, and I'll come back to the speech in a moment, but how can you say that when we all can see full well that clause 47.5 of the Bank of Mauritius Act still provides for the Special Reserve Fund to transfer monies to government for repayment of central government external debt obligations. Black on white. And then we are told in a speech by the Minister of Finance that this no longer exists. But it's there in the law. It's not being removed. Other provisions are being removed, but not this particular one. So I'd like the Honourable Minister later on to correct this. There is still the danger, still lurks in the amendment that was brought, I think it was 2018, 2019. It was brought, a dangerous amendment was brought to the Bank of Mauritius Act. That amendment is not being reduced, and we'll take care of that in a moment, Mr. Speaker. What are we doing in this finance bill? We are doing two things. We are saying that the use of official reserves to invest in a company, i.e. the MIC, will no longer be possible. It's very technical, this discussion. I can't help it. The emphasis must be on official reserves. He will no longer be able to use official reserves to invest in a company. That doesn't mean that the Bank of Mauritius will not be able to invest in a company. No, no, no. It is official reserves that will not be used because the provision of section, what section? 6.1y says this, and this is not being removed. With the approval of the minister, the Bank of Mauritius can subscribe to, hold, and sell shares invest in any corporation or company set up for the purpose of facilitating economic development. So a quick reading of the bill this morning, today, will tell you that in fact it can no longer invest in MIC, but in fact it can still, but cannot use official reserves. And the second thing that is being said, so we maintain the possibility of investing in a company like MIC by the Bank of Mauritius, like the Bank of Mauritius, as if it's a state investment corporation, if you want, but we cannot use official reserves. And the other change that is being done today is that the Bank of Mauritius will no longer be able to use a special reserve fund to just give money to government as a gift. That is the two. But, again, the special reserve fund will continue to be able to be used by the Bank of Mauritius to repay central government debt, external debt. So it's a fine line. Whether you use the money to repay your external debt or you use the money just for budget support is out, but you can still use it for central government debt. Mr. Speaker, I'll take you back to 2019 when this government decided to use 18 billion rupees of the Bank of Mauritius funds to repay central government external debt. I particularly was very upset by that. I raised that many times. We showed that, in fact, this was wrong. Government continued on its way, ignoring us. We even showed, Mr. Speaker, I think it was not Minister of Finance, it was the Prime Minister who was Minister of Finance. Then we even showed that the IMF had severely criticized Seychelles at the time for trying or doing this sort of thing. It was ignored. Worse, with the new Minister of Finance, we qui peut plus, peut moins, qui peut moins, peut plus. This time, not 18 billion rupees was taken, but 140 billion rupees was taken. 140 billion rupees. That is 60 billion as budget support, 80 billion to the MIC. Now, how much is 150? In all, if you add it up, it comes to 158 billion rupees. We've never seen this. Most of Mauritians don't know what is 158 billion rupees. What is the difference between 158 billion rupees and 158 million rupees? Most people won't even know, Mr. Speaker. That is the problem, because it's a huge, huge, huge amount of money. It's, Mr. Speaker, I've taken one with the effigy of my father on it because it's only 1,000 rupees. In fact, Mr. Speaker, the Minister of Finance and his predecessor took 158 million of these. If you were to put them side by side on all the roads of Mauritius, I think you would cover all the roads of Mauritius and still have some left. So much you carpet the whole of the roads of Mauritius with this 1,000 rupee note just to show how much money was taken from the Bank of Mauritius. If you look at it another way, Mr. Speaker, you could give 150,000 households in Mauritius 1 million rupee, not 20,000 rupees. You could give 150,000 households in Mauritius 1 whole million rupee, change their lives completely, and still have 8 billion rupees left to do your hanky-panky. That is how much money. Sorry?
Table the note.
I'm sure, Mr. Speaker, you have much more than that in your bank account. Surely. Now, so that is, in fact, how much we took from the Bank of Mauritius. And how did that money arise in the Bank of Mauritius? How did it money? Is the Bank of Mauritius, have we had such a governor of the Bank of Mauritius that actually is such a whiz-kid financially that he's made billions of rupees for us that Mr. Binnick and everybody else before him could not do? No. Mr. Speaker, these monies come from the Special Reserve Fund. Now we have, at least one accountant there, maybe more. What is a special? Why is it called special? Ask yourself a question. Why is it not reserve? Why is it called Special Reserve Fund? It is called Special Reserve Fund, Mr. Speaker, because it's not true profits. They are paper profits, profits from revaluation. The more the rupee depreciates, the more the financial assets in dollars increase, and the more the Bank of Mauritius makes money. So in fact, Mr. Speaker, to generate this amount, huge amount of money, the Bank of Mauritius had depreciated the dollar since the 2014 elections by 42%. That is the only reason why this money has generated. Huge depreciation of the rupee, creating huge employment, huge inflation, huge rise in prices, huge misery, but huge amounts of money for the government, Mr. Speaker. So that is the situation. Now, Mr. Speaker, we know that the government is trying to say that when you look here, you look there, it's huge. The economy is doing so well. That is why we can spend. That is not true. Government is spending money that it has taken, not from the Bank of Mauritius, from these paper profits. That is what's happened. Because the economy has still not recovered in real terms from COVID. We are one of the few economies in the world that has not yet recovered fully from COVID. And yet when you listen to speeches of the government, it's as if we are prospering like anything. We are not even back to 2019 levels. We had, for a very short time, high income status. And then, whoop, we went down again to high middle income status. That is the truth. So it's not money that's been arising from great management of the economy, from huge growth. No. Growth still, as I said, the economy is still below 2019 in real terms. In dollar terms, it's much worse. Much worse. But in real terms, in real rupee terms, it hasn't recovered yet. And the money that is being spent is money that has come from, if I can say, fictitious profits, not real profits, arising not from the reserves of the Bank of Mauritius, but from the special reserves of the Bank of Mauritius. And the special reserves of the Bank of Mauritius, being special, was protected by a special clause in the Bank of Mauritius Act. There was a special clause there to say you cannot use it for this, that, the other. You can use it if you want for monetary policy, when you need it. And the government added this clause that you can use it to repay central government debt, and added this clause that you can use it just to grant monies to the government. As I said, part of it has been rescinded or is being rescinded today. C'est un petit pas. The other bit also has to be rescinded. That is, using the special reserve fund, paper profits, to pay for debts, central government debt. Because what's going to happen? It's another incentive for the government and the Bank of Mauritius to continue depleting the rupee, to continue depreciating the rupee. Once the rupee continues to depreciate, the SRF will go up, and this money can be transferred and pay the whole of the debt of government, if that is the objective. That is what can happen. In pure accounting terms, this is what can happen. And that is dangerous. And that is why, Mr. Speaker, that section of the law ought also to have been removed. And so we expect now that the World Bank, and long ignored on all these issues of transfers to Bank of Mauritius, and the IMF long ignored. I remember, Mr. Speaker, on 10th of May 2021, I sent him a letter, quite a long letter to the IMF, telling them that I thought this was unacceptable, and they replied to me. And they told me that they're dealing with the issue. And it's true, in their Article 4 assessment, they raised the issues which I had pinpointed to them. So, Mr. Speaker, now we are expecting, by June 24, I think, 2024, about 11 billion rupees worth of loan from the World Bank to help prop up our foreign currency. It's going to be in foreign currency. I suppose we will need it eventually probably to pay for flour and petrol, etc. That may be of concern to the government, Mr. Speaker. So, Mr. Speaker, just one thing. The dollar, Mr. Speaker, may not always stay as strong as it is now. It may depreciate with all the issues that are arising with the China and the BRICS and all that. Saudi Arabia trying to move away from the dollar. So a word of caution, because if the dollar goes the other way, that is going to destroy the balance sheet of the Bank of Mauritius, which are so thoughtlessly given away all this money to the government. And so, Mr. Speaker, that is a word of caution. As for the MIC itself, it still sits on, although you cannot no longer use reserves to pay for the MIC, it's still sitting on the balance sheet of the Bank of Mauritius. When you look at the Bank of Mauritius, sometimes it looks like you are in fact dealing not with the Bank of Mauritius, but with a state investment corporation, because it's got an investment there, companies there. And the issue, Mr. Speaker, is the MIC took 80 billion from the Bank of Mauritius. It spent about 50 billion. 30 billion is left. I remember I asked the PNQ here of the Minister of Finance, because I thought the board was acting totally irresponsibly. I'm happy, although whatever Minister of Finance may have said in this House, the board was changed a little time after. The famous Lord Desai, I won't go into detail, was left, he was sacked, God knows. New guy came in, new board came in. And I'm happy to say that PNQ had some results in that it put a break on so many little petits copains, copines who wanted to take money from the MIC. It did put a break on that. I can't say it put a 100% break, but I do know that this has been reduced considerably. The temptation was reduced when the new board came in, and obviously government knew that the opposition knew exactly what was happening at the BOM. We even had at that time copies of board minutes, etc. So, Mr. Speaker, what to do with the MIC? Who wants that baby? That baby, Mr. Speaker, is worth 50 billion rupees. The 30 billion unspent, hopefully the government will take and recapitalize the Bank of Mauritius. It's worth between 50 billion and 80 billion rupees, the MIC. Who can afford to buy that off the government of the Bank of Mauritius? Nobody has that sort of money. None of the institutions of government, be it SIC, this and the other, has that sort of money. So, Mr. Speaker, it's likely to sit there as an unwanted baby on the balance sheet of the Bank of Mauritius for some time. And that is also a sad thing, because it can be, Bank of Mauritius is being drawn into a lot of issues like managing companies that it should not be doing, Mr. Speaker. Therefore, Mr. Speaker, to conclude on this bit, there has been 50% effort in trying to clean up the mess that the government created when it passed laws to take money from the Bank of Mauritius, but there are still dangers lurking in the remaining clauses that have been inserted by government, like clause 47.5, which still remains on the books, on the Bank of Mauritius Act, Mr. Speaker. Coming to a related matter, coming to 69 now, so that you continue on this related matter, which is Public Debt Management Act, Mr. Speaker. Now, I said last time, and I meant it, that the inflation is the Minister of Finance's best friend. Yeah, we will prove it quite easily, Mr. Speaker, because, wow, public debt has fallen in percentage terms to 79%. Why? One reason is that, Mr. Speaker, when you're talking about 79%, what is the 79%? You're talking about public debt as a percentage of money GDP. GDP in current terms. The higher the inflation, the higher the GDP in current terms, whether or not you have added economic development, added economic activity or not. Even if you had no added economic activity, GDP would increase by 10% because that is the inflation rate. And so GDP goes up because of inflation, and the debt is in fixed terms. It doesn't increase at all. Obviously, some of the foreign debt will increase if the exchange rate goes against us. Otherwise, so you win all the time. Just by sitting still and doing nothing, the public sector debt falls at a time of high inflation. And that is the truth. But look, so we can no longer, unfortunately, just look at percentage figures that we would usually look at in a stable inflation situation. In a high inflation situation, you can no longer just look at the percentage terms. Let's look at the, if I may, let's look at the actual figures. Again, there's no mention in the budget of this. Huh? Actual figures, Mr. Speaker, when we left in 2014, public sector debt was 235 billion rupees. What does that mean? If you take 2014, let's say there's not yet 50 years, 46 years since independence. It took Mauritius 46 years to actually write up a debt of 235 billion rupees. And it took this famous government only 8 years to more than double this figure. What we took 46 years to arrive at a debt of 235 billion rupees, Honorable Padayachi and the others, they just took 8 years. And they added 250 billion rupees to the 235 billion. So the debt now, in absolute terms, is 485 billion rupees. Official figures, 485 billion rupees. Huge amount. You can see, therefore, that is inflation helping. Inflation is helping to drive artificially GDP so that the percentages fall. But the absolute amounts are horrendous. The absolute amounts are horrendous, Mr. Speaker. And this 485 billion rupees, it comes after use, not the whole 158 billion, no, but 78 billion rupees of the Bank of Mauritius. We have, this government has indebted this country to the tune of 485 billion rupees after having used 78 billion rupees of Bank of Mauritius funds. That is the enormity. That is why you see roads everywhere. That is why you see so many planes being bought. This is a new stadium. You have a new courthouse. This is where it comes. This is where it comes. Indebt us to the neck and use the money of the Bank of Mauritius. And they'll tell you, no, it's economic development. It's not economic. That's my main point. It's not economic development. And Mr. Speaker, what has all this done? It's given inflation. I raised last time, nobody said anything. Seychelles, 2% inflation. Maldives, 2% inflation. Mauritius, 12% inflation or 11%, Mr. Speaker. There you go, Mr. Speaker. And so now, we're setting the limit to 80%. And this limit of 80%, where is it? It's not in the law. It's not in the law. It's in the schedule to the law. Meaning that at a stroke of a pen, any Minister of Finance can just change it. GN so-and-so, 80% becomes 90% because of 100%. The other limit was in the law itself. You had to come to Parliament to change the law. Here, it is in the schedule, and it can be changed at the whim of any future government, Mr. Speaker, and that is a changer. The limit is not really any limit when it can be changed so easily. That is my point. And previously, Mr. Speaker, there was also some provisos that in terms of economic emergency, whatever, you could actually increase it. But the previous law was for again, it was in the law, in the act itself, it could increase only by 2%. Meaning that if you take it to current figures, had we maintained the 2% maximum increase that it could have gone in case of emergency, large contracts, etc., meaning that it would be about 14 billion rupees that government could have used. But no, government had decided that's not possible. It's not enough. If we need to spend, we really want to spend, take out the checkbook and spend. And so the 2% limit that was in the original bill, the public sector debt in the original bill, 65% reducing to 60%, with a proviso that you could increase under special circumstances by 2%. Here, the 2% has gone. The special circumstances have stayed, the 2% have gone. So, Mr. Speaker, this is just This is just to please the eye. It has no importance. Putting the debt in a schedule, removing the 2%, it has no bite. It has no bite. It is not any constraint on any Minister of Finance, Mr. Speaker, sir. Mr. Speaker, I'm going to leave the financials situation. I'm going to come to the Early Childhood Education Authority, clause 23. And here, Mr. Speaker, we are asked to vote for a number of amendments to enable the Minister of Education to operationalize the free pre-primary education. The first announced this in March, on the 4th of March. And you would have imagined 4 months later that the Ministry of Education, when asking us to vote for this, would actually tell us, or the Minister of Finance, what is meant by free pre-primary education. What is going to be done? How much money is going to be given? Is it going to be given on a per capita basis? Is it going to be given on a cost-plus basis? How is it going to be operationalized? Will it be given to children attending half-day pre-primary, three-quarter day, up to 3:30, or what I hope is up to 5:30, full day, meaning that, in fact, mums and dads can actually work and leave the kids at the pre-primary school. This is what we expected of a responsible government to come and tell us. I think the Minister of Education will speak later on. So I have some questions for her as to how is it going to apply? Why should we vote for something not completely in the dark as to what will happen to pre-primary education? Because I've had a little bit of, made some research. Now, I have a very good one, a very good pre-primary school in my village in Grand Gobe, Mr. Speaker. It charges 1,000 rupees, plus it gets 400 rupees grant from government, I think, which I started myself in 2013. 1,400 rupees. I know of some kids that are paying 6,000. Other kids that are paying 8,000. Others are paying even, the very rich kids, 12,000. So, which is what is going to happen? We can't just vote for something and not know what figure this lady, the honorable lady, has in mind. What is being proposed? As I say, is it going to be per capita? I'm going to give 2,000 rupees, 3,000 rupees per child? Or am I going to do like the mess that is created in the grant-aided schools, where it is a cost-plus basis, principally? It's a mixture. So, Mr. Speaker, I think we're entitled to know, because Section 108, which is being asking us to vote today, just says this: the subsidy will be determined in accordance with such criteria as the authority will determine. Is this serious that we are asked to give a blank check? To give a blank check? And, Mr. Speaker, I'm told that a large number of these pre-primary schools have been closing down because of the mismatch between regulations and revenue. And the greater the regulation, if they are necessary, fair enough, but if they are unnecessary, then they just create a hindrance, and the owners of these pre-primary schools close down. I'm going to take you an example, Mr. Speaker. To get a permit for your school, you need a building and land use permit. Now, what is a building and land use permit got to do with this? You just look at the premises, and if they are good, you approve them. Why take all this time, all this unnecessary regulation? There's a big debate in the UK, Mr. Speaker, as to the level of control that you should have on these kindergartens and pre-primary school, so that the more control may be good, but the higher the price to the child, meaning that the child may have to skip pre-primary school. So you need an equilibrium between regulation and cost to the school, so that, in fact, not only do you have decent, secure, safe schools, but also plentiful of schools for the children, Mr. Speaker. And that is, I'm told, that a large number have closed, and a large number of other schools operate without a permit at all. Neither, Mr. Speaker, are acceptable. We have to look again at how the regulations work out and cut out the non-essential red tape and allow these schools to flourish in the right conditions. That is what I had to say, Mr. Speaker, because, as I said, it's very important. As I say, after 8, it's already too late. I've said this in the House many times. You need to catch these young kids as early as possible. And this is from 3 years old. We agree on this. 3 years old to 5 years old, let's catch them as early as possible. But for God's sake, give us some identity. 4 months after the announcement, give us some indication of what's going to happen before we vote this part of the bill, Mr. Speaker. Sir. Mr. Speaker, I come to clause 24. I said I was about 12. Clause 24, Economic Development Board. Now, this is what's going to happen now, Mr. Speaker. We are going to enlarge the premium investment scheme. You're going to give the power to the Minister of Finance to play Bonhomme Noël. Father Christmas. You are an investor, premium investor, come. No need to pay taxes here. This is cloud cuckoo land. Don't pay taxes. You have fees, don't pay for fees. Regulations, I'll get rid of them. It is a blank check to the Minister of Finance of the day to decide what goodies to give to a premium investor. That is the premium investor scheme. Now it is being enlarged so that anyone who wants to purchase government property will be able to do so, and will be able to ask the Minister of Finance, well, what control, what check and balance you're going to have? None, except that it's going to supposedly to be disclosed later on the website of the EDB. No checks and balance at all. Mr. Speaker, this is my issue. Sale of government property don't need to go by tender. When you buy, government buys something, except with all the loopholes that have been created, when you buy something, you're supposed to go by tender. When you sell, you don't. So, Mr. Speaker, c'est au gré by gré, whatever, it's one-to-one, one-to-one. Someone comes and says, I want to buy casinos. Oh, yes, you want to buy casinos? What exactly would you like, my friend? I don't want to pay any taxes in Mauritius. No, no, no. Remove the gaming tax from the casinos. Give me rent-free for 10 years. Oh, this is possible under the premium investor scheme. Do you think that this is reasonable in a democracy where you're supposed to have transparency and checks and balances? Because this is not a tendering process. This is a one-to-one process. The risks are huge, Mr. Speaker. Sale of public assets, Mr. Speaker. We don't want to end up like Russia with local magnates having bought assets on the cheap and suddenly found they are multi-billionaires. We don't want that. We want the thing to go correctly. And this is why, Mr. Speaker, I'm absolutely against these provisions. Absolutely against these provisions. You cannot give a blank check to the Minister of Finance, whoever he may be, to decide on what rate of income tax someone's going to pay, what rate of gaming tax someone's going to pay, etc., etc., etc. This is not acceptable, Mr. Speaker. This is not acceptable. Not acceptable. And sometimes you can even have private assets disguised as lame ducks and sold off. Ah, I couldn't find a buyer. I'm giving him the world. Dangerous, Mr. Speaker. It allows the Minister of Finance to give rebates, to give tax exemptions, to give preferential rates, reduction in taxes, reduction in duties, special deals on land and buildings, even utilities. Even utilities. Ah, don't pay the CEB, that much they don't deserve. You pay half, my friend. And so on and so forth, Mr. Speaker. Unacceptable, Mr. Speaker. Now, I've come to another unacceptable bit, the famous Pharmacy Act. Ah, yeah, yeah. 3 years ago, 4 years ago, we were told that we were going to have a pharmacy industry in Mauritius making medicines. Of course not. You can't, with a cowboy ministry, have a pharmacy pharmacy industry here. Because the pharmacy industry, above all, it relies on trust and confidence in the product that you're buying. When you take a pill, you don't know what's inside that pill. It's got a name, it's got a manufacturer, and that's it. It could have anything. Maybe if you're taking Nexium, it has maybe none of the active ingredients. You don't know. And so the pharmacy industry relies only on reputation and trust and regulation. And when we talk about the Ministry of Health, it has no one on its staff capable of regulating in any way the manufacture of medicines in Mauritius. No one, not a single person on his board capable of doing that. And yet, year after year, we try to sugar the pill, and yet again this year, this clause 36D that is being proposed as an amendment to the Pharmacy Act gives now it gives a shortcut. You go, ignore this shortcut. You go and manufacture in Mauritius. No problem, sir. Come and manufacture. What do you need? You need to have a good manufacturing practice certificate. And he said a WHO, and this is what the misnomer is, a World Health Organization good manufacturing practice. But if you know what you need to know, Mr. Speaker, is that the WHO, OMS, only gives guidelines. These guidelines are published as good manufacturing practice. It is up to the country where the manufacturer is to give the certificate that it complies with the good manufacturing practice of the WHO. WHO itself does not give a certificate. And I'll tell you what it is now. So now, if you have a company in Mauritius, it wants to have a shortcut to produce medicine to sell to the local population. I don't think it will be able to export. What it does, it signs an agreement, a transfer of technology agreement with another company that has a WHO good manufacturing practice certificate. WHO being a misnomer, it is only a guideline. Now I'll tell you an example, Mr. Speaker. Let's say that the pharmacy company is set up in Nigeria. Now, the WHO will give the guidelines. It is up to the Nigerian health authorities to deliver the GMP. And this Nigerian company, or Tanzanian company, or Chinese company, whoever company, can actually come and set up under a technology transfer agreement here and manufacture. What faith are you going to have? Mr. Speaker, this is dangerous for the population in Mauritius, because some countries will deliver the GMP properly, and some will not. If you're telling me it was in the US, in France, in England, in some other countries, I might believe you. But what about other countries, borderline countries? And that is where the danger is, because the only requirement that the law gives here for this to go ahead is that you hold a GMP under WHO guidelines delivered by some country or other. That is the danger, Mr. Speaker, sir. And anyway, what is the point of manufacturing in Mauritius? Are you just going to manufacture because you want a contract from the Ministry of Health? Well, is that going to what we're going to be able to attract? Or some poor fellows around the world who want to benefit from some contract from the Ministry of Health to supply Panadol or whatever it gives by the millions every year? Or do you want a company that's going to be able to export? And given the weakness of our regulatory authority here, no one will register medicine manufactured in Mauritius. No one. No one will register, because they will know full well that we don't have any capacity to regulate it. We don't have even a decent testing lab. So, Mr. Speaker, it looks to me that the whole point of this amendment 36D is to facilitate some poor fellow wanting to come to Mauritius to manufacture some pills for sale on the local market, for sale to the Ministry of Health point I can see. Because you will not be able to afford. No one's going to buy under these conditions. And Mr. Speaker, industry are extremely worried about this. Because one bad batch of medicine that you sell, let's say you sell either Mauritius or overseas, one bad batch, some poor fellow falling ill somewhere, some poor fellow dying, not one, maybe more than that, destroy the pharmacy industry forever. So this is a case where you need to stop high and expand. It is not the case, the industry where you start by slow and rise. Like as if, Mr. Speaker, you want to go into textiles, you start manufacturing clothing and underwear. I can understand. Eventually you go and manufacture goods. That's okay. But this is not what you want to do in the pharmacy industry. You want to start high. I have a few more bits, Mr. Speaker. The Workers' Rights Act. Mr. Speaker, we need to be able to get the right balance between productivity and work. Because productivity gives high wages, gives high value added, gives prosperity to the workers. I'm going to ask you about this, and this is clause 90, by the way. I'm going to ask you about this particular amendment that is being proposed. I don't understand how any government can propose this. Whereas it's absolutely correct to say that if your child is sick, the parents, or one of the parents, would be able to take some holiday to care for it. I have no issue with that, and count with sick leave. But, Mr. Speaker, to say, as the law is drafted, that if your grandparent is sick, then not only all the children can take the 10 days, all the grandchildren can take the 10 days, that is not, Mr. Speaker, good economics. I'll take an example. I take the example of the president of the party, Veronique. She has 8 sisters and brothers, 8 of them in all. They have 17 grandchildren. If the grandma is sick, would you find it acceptable that all the 25 take 10 off and therefore the economy loses 250 days' work? Do you find that acceptable? Is that crazy economics? This is what is being proposed. I can understand fully when someone is under care of someone. My mother is living with me. My mother is in the UK. If she is sick, I might be able to take 10 days off. That's because she doesn't fall sick. Now, if the person is in the care of the person, that sort of thing, I can understand that one child very seriously, this, Mr. Speaker. As far as childcare facilities are concerned, I'm all for it, but we have to clarify because some people may be employing 250 employees or more, but not on one site. They may have 10 sites. They may have 20 sites. So what happens then? There must be provision for them to be able to contract out this 1 to 3 years childcare service. Otherwise, it doesn't make sense that you would say, fine, that Kentucky Chicken or whatever has to operate 15 weeks. So that has to be It's a small point, Mr. Speaker, but it's important that I clarification on that. Mr. Speaker, the Dental Council Act. Now, we're going to have complete government control on the Dental Council. Complete government control. Out of 14 members, only 5 will be private. The rest are going to be government doctor, dentists I'm talking about, government dentists, or directly appointed by the minister. And he will tell you here on your answer, it's not me, it's the Dental Council that decided. There's nothing independent about the Dental Council. Same goes, Mr. Speaker, for the Medical Council. Nothing independent about the Medical Council. Out of 23 members, Mr. Speaker, 17 are the government employees or directly appointed by the Minister of Health. So nothing independent about either the Medical Council or the Dental Council, and yet successive people will hide behind this to say, it's not me, it's the Dental Council. And this is, Mr. Speaker, unfortunate. I come now to the shooting and fishing leases, the famous shooting and fishing leases. Some amendments are being brought. I would have thought, Mr. Speaker, that the Honourable Minister would have put one additional bit, that is, that should be leased to fit and proper persons. Should be leased to fit and proper persons. Because he's always issue, having inadvertently, I presume, inadvertently giving it to a famous drug trafficker. He didn't know about it, fair enough, but at least correct it today. I would have expected, in good faith, he would have said, I'm going to have this fit and proper person, as you do many other things. Even if you want to go and have horse races, you have to be fit and proper, but that would have been an occasion ratée. You could have, you see, I'm being very fair. You could have put that in the law. I hope it was not deliberate that you did not do so. Mr. Speaker, on the Roads Act, Mr. Speaker, I'm just going to say this. When you have a fine, you have to go personally to the district court to pay for it. If you were traveling in Grand Bay and you live in Maibo, and you have to, do you know how much time this costs the economy? How much wastes of time? When in fact you can pay easily digitally. You have Juice, you have Blink, God knows what else, MRA, etc. And yet, 2023 in Mauritius, when you have a fine of 1,000 rupees, 2,000 rupees, whatever, you have to go to the district court and pay. That is symptomatic of the dysfunctionment, Mr. Speaker, of government in this case, Mr. Speaker. Financial Intelligence and Anti-Money Laundering Act, we were promised amendments in the annex. I can't see any amendments. Good thing, because it was a bad provision. Everybody was afraid, because the annex announced that the Minister of Finance was going to remove, s'il vous plaît, fintech from the ambit of the Financial and Intelligence and Anti-Money Laundering Act. Many people were afraid whether, in fact, what's it called, the Bitcoin, etc., was now going to be out of the financial FIMLA. But it didn't happen. Very good, Mr. Speaker. One general point, licenses. Everywhere in this bill, licenses are being given for 1 year. Everywhere. What a mistake. You want people to keep on applying every single year? Previous government, Mr. Speaker, we have tried to extend the life of licenses from 1 year to 3 years. You don't want the whole nation to keep on reapplying every single year for every single license, which is being done here. You don't want our civil servants everywhere just to be stamping payments for every single license every year. That is a big mistake, and this book is full of these instances where licenses are being paid every year. What? Same as going to pay for your fine physically in the district court. Licenses annual should be a thing of the past. You should be giving the choice, at least, or paying 3, 4, 5 years in advance and be safe. What's more, Mr. Speaker, not having your license, having your license renewed for only 1 year is a huge source of uncertainty. Stops you from investing properly, not knowing whether year by year your license will be removed. And the last point, Mr. Speaker, the Public Procurement Act. Now, the Public Procurement Act, to be on the safe side, I will give you the clause 69. 69 Public Procurement Act. Public Procurement Act, it says now the prescribed amount, that's all it says, huh? The prescribed amount will now be, it says here, prescribed amount means such amount as may be prescribed. Seems to make sense. Now, what is doing actually, Mr. Speaker, is allowing for schedules to the account, to the Act being changed, because each type of entity, each company has a prescribed amount higher than which it needs to go to the Central Procurement Board for allocation of a contract. Lower than this amount, it can do so by various ways. Fair enough. We don't know what is a prescribed amount that the minister will give. We don't know. But what we do know, Mr. Speaker, that this was a fantastic chance for the government of Mauritius to change that Schedule 1 of the Public Procurement Act by including companies like National Social Living Development Corporation, by including other companies that it seems to me now are deliberately being left out. Because here we are changing Schedule 1, changing the Public Procurement Act for the prescribed amount, but not changing anything to do with the prescribed organizations. That is my point. Mr. Speaker, I'll give you this and you will see very clearly what I'm saying. NHDC, National Housing Development Corporation, yes, it is on the schedule, whatever prescribed amount. By magic, deliberately, now we understand, NSLD, recently created, is not. NHDC constructs houses, and we can see NHDC houses are relatively cheap. And it has to abide by the Public Procurement Act, which is the Bible for procurement, but its subsidiary, the NSLD, it doesn't care. It doesn't care about that. Never heard of the Public Procurement Act. It doesn't need to. Prescribed amount change, not prescribed organizations. State Property Development Limited, the precursor of Landscope. State property, it can sell, Mr. Speaker, differences also between governments here. State Property Development Limited, yes, on the Public Procurement Act as a prescribed organization, but Landscope, no. Landscope, no, doesn't know anything about, doesn't want to know anything about the Public Procurement Act. The State Investment Corporation, Mr. Speaker, is a prescribed organization, has to abide by the Public Procurement Act. Would you be surprised if I told you that MIC, Mauritius Investment Corporation, is not under this government? And I've just taken a few. There are dozens and dozens of entities like this, deliberately kept out, I can say deliberately now, kept out of the Public Procurement Act, Mr. Speaker. There you go, Mr. Speaker. I've finished. Thank you very much.
Honourable members, I'll suspend the sitting for 30 minutes.